The moment my ex-husband looked across the courtroom and said, "Your Honor, she's nobody," the room shifted slightly. Not dramatically, not with gasps. Just that particular quiet that settles over a space when people are waiting to see what happens next. I remember smoothing my hands across my navy blazer the same way I used to smooth deployment maps before a briefing. Old habits. Steady hands when everything else is uncertain. Gary stood there in a charcoal suit that probably cost more than my first military paycheck. His attorney leaned close, murmuring something. Gary nodded confidently, the way men do when they've already decided how the story ends. He had been deciding how my story ended for 27 years. Then the courtroom door opened behind the bench. The bailiff's voice cut through the room cleanly. "All rise." And what happened in the next 45 seconds changed every assumption Gary had. Spent the better part of 3 decades building about me. But I'm getting ahead of myself. Let me start where it actually matters. My name is Patricia Hollis. I'm 61 years old. For most of the last decade, I lived quietly in Annapolis, Maryland, in a small house 3 blocks from the water, with a garden nobody ever saw except me and the occasional neighbor walking their dog past the fence. I taught part-time at a community college, constitutional law primarily. I drove a sensible sedan. I attended the same church every Sunday. I brought casseroles when neighbors had surgery. Nobody looked at me and saw anything remarkable. That was fine. After enough years of remarkable, ordinary feels like a gift. What most people in my neighborhood didn't know, and what Gary had somehow managed to forget entirely, was that for 22 years before I moved into that quiet Annapolis house, I had served as a federal judge in the United States District Court. Not remarkable by my own telling. Remarkable because of what it meant when Gary finally remembered. Gary and I married in 1987. I was 34. He was 38. He was a civil engineer with a successful firm in Baltimore, confident, funny, the kind of man who could make a dinner table feel like a celebration just by sitting down. I loved those qualities for a long time. What I didn't fully understand until later was that confidence in Gary had a particular condition attached to it. He needed to be the most significant person in any room, not the loudest, exactly, just the most important. And for years, that arrangement worked between us because I was not particularly interested in importance. Military families understand this. You learn early that real authority rarely announces itself. The most dangerous person in any room usually looks like they have nowhere particular to be. I had served as a JAG officer for 11 years before transitioning to civilian federal practice. Gary knew I was an attorney. He knew I worked in government. The specific nature of my position was something I disclosed completely at the time of our marriage. Gary simply never paid sufficient attention to retain it. That became a pattern. Years passed. Our son Marcus was born. Our daughter Claire arrived 3 years after that. Life filled with school pickups, holiday dinners, little league games, the comfortable noise of family. And somewhere inside all that noise, Gary slowly rewrote the version of me he chose to carry. By the time Marcus entered high school, Gary's version of me had become fixed. I was the quiet one, the background one, the woman who managed the household while he ran the firm. Whenever his business colleagues came for dinner, Gary answered questions about the legal system that I could have answered better. I let him. It seemed harmless. Looking back, small surrenders have a way of becoming architecture. The marriage ended in our 27th year. Not dramatically, not with cruelty, exactly. Just with a particular exhaustion that arrives when 2 people have been performing a version of their relationship for so long that neither one remembers the original. We separated amicably enough, agreed on most things, filed the papers without significant conflict. The disagreement arrived 18 months later when Gary decided he wanted the lake house. The lake house sat on 42 acres in western Maryland. I had purchased that property myself in 2001 using proceeds from a federal settlement I had overseen and income accumulated during my judicial years. Gary had enjoyed the lake house for 15 years without ever asking where the money to buy it came from. Now he had decided it belonged equally to him. His attorney filed a motion to reopen asset distribution proceedings. The argument was straightforward. Gary claimed I had deliberately concealed financial resources during the original divorce settlement. That was the moment I understood this was no longer about the lake house. It was about Gary refusing to accept that the woman he had spent decades describing as nobody, had built a life that belonged entirely to herself. The morning of the hearing, my daughter Claire drove me to the courthouse. She had insisted. She was 31 by then, a pediatric nurse in Baltimore, the kind of person who shows up when things are difficult without making a production of showing up. She gripped the steering wheel slightly too tightly the whole way there. "Mom," she said finally, "he's going to humiliate you in that room." I looked out the window at early October leaves drifting across the highway median. "Probably," I said. "You don't seem worried." "I'm not particularly." She glanced at me sideways. "Why not?" I thought about how to answer that honestly. "Because I've been in that courthouse before," I said finally. "Just not from that side of the bench." She didn't fully understand what I meant. I didn't explain further. Some information is most effective when it arrives without preamble. The courthouse in Annapolis was familiar to me in the way that institutions we spent years inside become familiar, not nostalgic exactly, just known. The smell of old wood and institutional coffee. The way sound flattens in marble hallways, the particular silence of a courtroom waiting for a proceeding to begin. Gary and his attorney were already seated when Claire and I entered. Gary looked comfortable. He always looked comfortable in rooms where he believed the outcome was settled. He had brought his attorney, a younger man named Caldwell, who had a reputation for aggressive asset litigation, and 3 thick binders arranged with the quiet confidence of people who believe volume equals preparation. I sat across from them at the opposing table alone. No attorney, just a legal pad, a pen, and a single manila folder. Caldwell noticed the folder immediately. I watched him calculate its thinness and relax. Gary looked at me from across the room and shook his head faintly, almost pitying, the expression of a man who believes he already understands what is happening. He leaned toward Caldwell and said something low. Caldwell smiled. Claire sat directly behind me in the gallery. I could hear her breathing change. The bailiff appeared near the side door and called for the room's attention. "This proceeding in the matter of Hollis versus Hollis will come to order." The Honorable Judge Raymond Ashby presiding. The courtroom door opened, and I watched Raymond Ashby walk in. I had known Ray Ashby for over 20 years. We had served on the federal bench simultaneously during much of the 1990s. He was 8 years my senior, sharp as anyone I had ever worked alongside, and possessed of a particular quality I had always admired. He was completely unbothered by reputation. He cared about law and about conduct, and he cared about very little else in a professional setting. He crossed the room with the measured step of a man who had entered courtrooms thousands of times. He settled behind the bench, arranged his papers, then looked up to survey the room. His eyes moved from Caldwell to Gary, then they found me. For 3 full seconds, he was still. Then Raymond Ashby stood back up from his seat. Slowly, deliberately, he looked directly at me. "Bailiff," he said calmly, "please ask everyone to rise." The bailiff blinked, confused by the timing. This was not standard procedure. Court had already been called to order, but Raymond Ashby was already on his feet, and he was already nodding. "All rise," the bailiff said. The room stood. Judge Ashby extended one hand toward me in acknowledgement the way senior federal judges acknowledge one another when they share the same space. "Your Honor," he said quietly. 2 words, just 2 words, but the entire room heard them, including Gary. I watched Gary's face change the way a landscape changes when weather arrives. First confusion, then something working behind his eyes, then the slow, unmistakable arrival of understanding. Not the version of understanding that arrives with grace, the version that arrives too late. "Please be seated," Ashby said, returning to his own chair. He opened the case file and did not look up again for nearly a minute. Behind me, Claire made a sound so small that only I heard it. Not a word, just breath releasing. The hearing proceeded. Caldwell stood and delivered his prepared argument, though with noticeably less authority than he had entered the room carrying. He described Gary's position carefully, thoroughly, professionally. Then he made his central claim. He stated that I had withheld significant financial disclosure during original settlement proceedings. Judge Ashby looked up from the bench. "And what specifically was withheld?" he asked. Caldwell explained. "Real estate holdings primarily, the lake property in western Maryland." His argument was that I had failed to accurately represent my income history and asset base during settlement. Ashby nodded slowly, then looked toward my table. "Mrs. Hollis, would you like to respond?" I stood. "Yes, Your Honor." I opened my single manila folder and removed 3 documents. The bailiff carried copies to the bench. Judge Ashby reviewed the first page, then the second. His expression did not change dramatically, it rarely did. That had always been one of the things I respected about him. These appear to be original settlement documents, he said. Yes, sir. Specifically, pages 11 through 14, in which I disclosed my judicial income, my federal pension entitlements, my investment accounts, and the real estate property in question, completely and in full. The room was very quiet. Caldwell cleared his throat. He stepped forward and asked to review the documents. Ashby allowed it. I watched Caldwell read. The younger man's shoulders settled slightly. Gary was watching his attorney with the expression of someone waiting for a signal, and the signal was not coming. After a moment, Caldwell spoke carefully. He suggested that the disclosures might have been technically present, but practically obscured. Judge Ashby removed his glasses. Are you suggesting, he said evenly, that a retired federal judge failed to understand her own disclosure requirements? Caldwell paused. No, Your Honor. He sat down. The hearing lasted another 40 minutes. During that time, Gary spoke once. He was given the opportunity, and he took it. He stood and looked toward the bench and said, with the remnants of his original confidence still faintly audible, that he simply felt the assets had never been properly divided, that as her spouse of 27 years, he deserved consideration. Judge Ashby listened completely. Then he said, in the tone of a man who has heard many variations of many arguments over many decades, Mr. Hollis, the court finds no procedural basis for reopening asset distribution. All disclosures were appropriately filed. Your motion is denied. He closed the file. That was it. No dramas, no speech, no extended consequence, just the clean, quiet efficiency of a proceeding that had never been in genuine doubt. Afterward, in the courthouse hallway, Claire held my arm tightly while people moved around us toward exits and elevator banks. She didn't speak for almost 2 full minutes. That's my daughter. She has always needed time to process before words arrive. Finally, she stopped walking and turned toward me. When did you know the judge would be Ashby? I hadn't known. Not specifically. The assignment had been random. These things usually are. But here is what I did know, and what I had understood since the moment Gary's attorney filed that motion. Courtrooms have a way of revealing people. Not because of drama, not because of arguments or theatrics or confident attorneys with thick binders, but because evidence is patient. Truth doesn't require performance. It simply requires the right room and enough time. Gary had spent 27 years deciding who I was. He had decided I was the quiet one, the background one, the woman who needed his interpretation to make sense of the world. And he had believed that version so completely that he had dragged it into a federal courthouse and tried to argue it as fact. The courtroom simply showed him otherwise. That evening, Marcus called from his apartment in Washington. He had heard from Claire. His voice on the phone was different from his sister's. Where Claire processes inward, Marcus processes outward. Mom, he said immediately, why didn't you ever tell us the whole story? I thought about that carefully. Because there was never a reason to make a production of it, I told him. He was quiet a moment. Dad really thought you were a nobody. He thought the version of me he'd invented was the whole person, I said. And you let him believe it? I smiled faintly at the phone. I didn't let him believe anything, Marcus. I simply didn't argue with him. There's a difference. He laughed under his breath. Then, more quietly, were you ever angry? Honestly, yes. Not at Gary specifically. At the particular exhaustion of being simplified by someone who once loved you. People do that when marriages unwind. They take the version of you that makes the story easier, and they defend it stubbornly. Gary needed me to be nobody because it made his own choices feel more understandable. I never gave him the argument he wanted. I gave him the courtroom instead. In the months that followed, Gary and I did not speak directly. That was fine. There was nothing urgent remaining between us. Claire reported occasionally, the way children of divorced parents sometimes serve as reluctant couriers of information. Gary had grown quieter, she said. Less quick to explain things to rooms, less certain, somehow. I didn't celebrate that. I didn't mourn it either. I simply noted it. Because here is the thing about people who spend years underestimating others. The damage doesn't live in them. It lives in the underestimated person, quietly, patiently, beneath ordinary mornings and sensible sedans and casseroles brought to recovering neighbors. And one day, when the right room and the right moment arrive, the truth becomes undeniable. Not loud, Not triumphant, just finally completely visible. I was back in the garden 2 weeks after the hearing. October had turned cold by then. The hydrangeas needed cutting back before frost. I had my old gloves on, the ones with the torn left thumb that I keep meaning to replace. My neighbor from down the street stopped at the fence, the way she sometimes does on her morning walk. She mentioned she'd seen something in the county court records, something about a case with my name. She wasn't being nosy, exactly. Just curious the way people are in small towns. Were you really a judge? She asked. Retired, she blinked. For how long? 22 years. I told her and went back to the hydrangeas. She stood at the fence a moment longer. Why does nobody know that about you? I looked up. Because I never needed them to, I said. And that, I have come to believe, is the truest thing I know about quiet strength. It doesn't require an audience. It doesn't require defense. It only requires patience and eventually the right room. If this reminded you of someone in your life who has been underestimated, or perhaps someone you may have underestimated yourself, I'd love to hear your thoughts in the comments. We all carry more than people see, and sometimes the most powerful thing any of us can do is simply wait for the moment the room figures that out on its own. Thank you for spending your time here. I hope you'll stay for the next one.